While not directly a letter from Sarah Boone, this is on the docket and is very important for anyone trying to follow this case. Motion to intervene for the limited purpose of opposing closure. WFTV TV Channel 9, WFTV, moves to intervene in this action for the limited purpose of opposing closure of judicial proceedings. In support thereof, the WFTV states as follows. WFTV has covered the murder of George Torres, the arrest, investigation, and prosecution of defendant Sarah Boone. Reporters from WFTV attend court proceedings and rely upon state, county, and local public records as well as judicial records as part of their news gathering process. The court has set a physical viewing of the evidence for September 3rd, 2024, and is set to consider the media's attendance at the viewing during a hearing on August 14th, 2024. Any closure of the physical viewing directly affects the media and the public's right to monitor this important criminal proceeding. As such, WFTV has standing to intervene and oppose any requested closure. See Miami Herald Publication Company versus Lewis, I believe. WFTV would like to be heard in this matter and asserts that any requested closure should be denied. Now, if they're going to be heard in court and Sarah Boone's going to be there and the media is going to involve themselves in any way in her case, we can imagine how she will react. And just so you know, I might not cover what happens live in that courtroom, partly because I don't know how to do that legally, what feed would be possible to do without copyright problems. But they are out there, and the hearing is tomorrow, so I wanted to get this out for you because it could be interesting. Florida has traditionally served as a model for open government in courts. It is well settled in the state that criminal court proceedings are presumptively open to the public. The Florida Supreme Court has stated that a trial is a public event, and what transpires in the courtroom is public property. Therefore, when considering a request to close court proceedings, this court should begin its consideration with the assumption that a pretrial hearing should be conducted in open court, unless those seeking closure carry their burden to demonstrate a strict and inescapable necessity for closure. In order to justify closure, the moving party must meet an exacting standard and show closure is necessary to prevent a serious and imminent threat to the administration of justice. No alternative other than a change of venue would protect the defendant's right to a fair trial. Closure would be effective in protecting the rights of the accused without being broader than necessary to accomplish that purpose. They have some more information there at the bottom you can read if you want. First, closure is not necessary to prevent a serious and imminent threat to the administration of justice. Importantly, the fact that the proceedings will involve viewing evidence does not alter this court's Lewis analysis. See State versus Lugo. The need to examine evidence for its admissibility is not one of the prongs set forth in Lewis. It is not sufficient to justify closure. Suppressing a defendant's statement that included potentially damaging admissions for refusing to seal the statement because even where pretrial publicity includes publication of inadmissible evidence or confessions, a defendant can still receive a fair trial. And any attendant publicity is not synonymous with prejudice, as the Supreme Court explained. Prominence does not necessarily produce prejudice and juror impartiality. We have reiterated does not require ignorance. Jurors are not required to be totally ignorant of the facts and issues involved. Scarcely any of those qualified to serve as jurors will not have formed some impression or opinion as to the merits of the case. Every case of public interest is almost as a matter of necessity brought to the attention of all intelligent people in the vicinity. Scarcely anyone can be found among those best fitted for jurors who has not read or heard of it, and who has not some impression or some opinion in respect to its merits. A presumption of prejudice. Our decisions indicate it tends only the extreme case. Skillings v. U.S. Pretrial publicity, even pervasive adverse publicity, does not unequivocally lead to an unfair trial. As such, media attention alone is not sufficient basis for closure. See Kozma. Even massive pretrial publicity about a case is not enough to show a serious imminent threat to the administration of justice or the denial of a fair trial rights. Second, alternatives to closure exist to protect the defendant's fair trial rights. For example, traditional techniques during jury selection can be used to insulate the jury from consequences of publicity. Noting that when considering whether there's an imminent threat to a defendant's fair trial rights, a court should consider whether traditional judicial techniques to insulate the jury from consequences of such publicity will eliminate the problem. State v. Shero. Finding defendant failed to meet burden to justify closure of proceeding hearings in part because the court could effectively protect the defendant's right to a fair trial through the jury selection process and insulate an impaneled jury from additional coverage. Finally, closure would be ineffective and broader than necessary to protect the defendant's fair trial rights. When prejudicial information already has been made public, there will be little justification for closing a pretrial hearing in order to prevent only the disclosure of details which had already been publicized. Lewis. Here, this matter has been public since inception. There is no need to close proceedings now, see State v. Bush. There is no doubt that in this particular case, the information has already been well publicized. Accordingly, this court finds the defendant cannot meet their burden under Lewis. State v. Smith. As to the third prong of the Lewis test, the defendant failed to show that granting this motion would be effective in protecting against the perceived harm. Since much of this information is already made public, there is little justification for granting the motion. Rather than a hindrance to the administration of justice, Sixth Amendment rights, heightened public attention only increases the need for appearance of fairness, so essential to public confidence in the system. Press Enerco versus Supreme Court of California. Publicity is vital to an open and accountable judicial system. As former Supreme Court Justice Berger has explained, without publicity, all other checks are insufficient. In comparison of publicity, all other checks are of small account. Closure of judicial proceedings should be ordered only when there is a serious and imminent threat to the defendant's right to receive a fair trial, and even then, alternatives must be considered and restrictions must be narrow. In this case, there is no strict and inescapable necessity for closure, and this court should deny any such request. Therefore, WFTV requests this court allowed to intervene in this matter for the purpose of opposing closure and deny any requested closure of the September 3rd, 2024 proceeding. Now, as I said, this is the hearing on this is supposed to be on the 14th. I am recording this on the 13th. I'm going to put this out sometime in the afternoon of the 13th. So essentially, what has happened here is Sarah Boone's nightmare. I'm going to be honest, this is her nightmare. The media is basically challenging a closure she wants. They're challenging something she wants done in court. And we know she tried to question the media. Well, I know she tried to question the media in court, was told no before. She has, as I said, I've watched the court appearances, but I don't know how I could legally cover them. Other people do. I just don't know how you do it correctly. So I covered the documents. She has been very upset about the media presence. This was her attempt to get rid of the media. And the judge, I wouldn't say was open to it from my opinion. It was basically like, I have to look into the law. And now that we have this opposition and they're citing things, I guess we'll see. My expectation is the judge isn't going to let anything get sealed. But except, of course, they're not going to let the media see, like, I don't want to put this, like, photographs of, like, his body. But there was talk, I believe, of those being sent in a digital format anyway. But she's wanting to, like, examine the suitcase and things like that. I think that, I don't think the media will be kicked out, but maybe you do. So let me know what you think. We'll find out who's right and who's wrong probably tomorrow, unless it gets extended to yet another hearing. But probably tomorrow.